joined us here. So with that short and probably totally insufficient, I know for sure, insufficient introduction, let me introduce Rabbi Tzvi Haber for everyone, please.
Thank you very much, Rabbi Diamond. First of all, let me ask you, is the sound okay? Can everybody hear me?
We're good.
We're good. Okay. Rabbi Diamond, just on a technical matter, I noticed that share screen is disabled on my computer, but I would like to share some material.
So I am going to make you a co-host, and then you can do that.
Amazing. Okay. So first of all, I want to echo what Rabbi Diamond said. Shalom Aleichem to everybody. My name is Rabbi Tzvi Haber. I work at the COR, and I'll introduce myself a little bit more. I grew up here in Toronto, in this very community, Wilson and Bathurst neighborhood. I grew up in Rabbi Loewy's Aguda Shul. However, I lived close to Clanton Park. I davened there, as well as Rabbi Gottesman's Amuna Shlema Shul. And I went to Eitz Chaim, and then I went to Ner Yisrael, and I went off to yeshiva in Israel, to a yeshiva called Kol Torah, where Rabbi Shlomo Zalman Auerbach, Zecher Tzadik Livracha, was the Rosh Yeshiva. And then I came back to Toronto to serve this wonderful community as the director of community kosher at COR. Before I begin, I want to just reciprocate and echo what Rabbi Diamond said, which is that we had I thought I was going to reveal this, but we had the wonderful privilege of learning together in the summer. And I can tell you and your community with the utmost confidence, the Shari Shemayim Kihila is incredibly privileged to have Rabbi Elliot Diamond as their rabbi. I know that it's an interim position, but I think it's been ongoing for many, many decades, and Be'ez Hashem, it's going to be ongoing in any capacity in the future. I want to wish Rabbi Diamond, you're a wonderful rabbi. You're so lucky to have him. Good health and arichas yamim v'shanim. May Rabbi Diamond be zocha, may he merit to share an abundance of Torah with this community and with the entire Kehila of Toronto. Amen. Tonight, I'm coming in the capacity as the director, or perhaps the founder, of Halacha Institute of Toronto. And I want to introduce the Halacha Institute of Toronto, or the HIT as we call it, to this community. HIT is a purely halachic organization, which is created by the COR to act and advise on many halachic challenges that require specific organizational resources and cannot easily be managed by the local rabbinate. It's similar to COR, which acts as the arm of the local rabbinate, but strictly in kashrut. The Halacha Institute of Toronto, HIT, acts as an arm of the rabbinate in other areas of halacha, spanning all 4 sections of the Shulchan Aruch. HIT employs 1 full-time rabbi, in addition to the many, many hours of volunteer services that it receives from many of Toronto's community rabbanim. Some examples of our services that are offered, in no particular order, are advising on and building small eruvin, replacing lost ketubot, or fixing their mistakes. HIT is often engaged to perform halachic compliance reviews for dynamic businesses across many industries, including the construction industry, the retirement residence industry, and numerous others who seek our advice and how to provide their services, despite limitations of Shabbos and Yontif, as well as how to deal with the prospect of serving non-kosher food when necessary. HIT provides heter iskas, which we'll discuss, for businesses and personal loans that involve the prohibition of ribis, prohibited interest. It serves to ensure that last wills and testaments are halachically compliant, and it advises on questions of pikuach nefesh DNRs, living wills, and end-of-life shilas. Just last week, HIT was asked to research a new type of stove that uses a coil heating element called SensiTemp, which seems to turn on and off when a pot is placed on it or when it is removed to determine if there's any way to use it on Shabbos and Yontif. HIT provides mediation services in many areas of dispute resolution, and specifically in areas where Batei Din, where the Beis Din, is practically ineffective. A primary example of this is in the area of divorce mediation. From the perspective of financial support, custody, access scheduling, equalization payments, and many other details. The divorce area being an area that Batei Din are limited in their power to enforce. HIT's clients range from the average community member to multinational million-dollar corporations, if not billion-dollar corporations, from couples who want to reconcile their differences to those whose differences are beyond reconciliation. Working at HIT is sometimes intriguing, and it's always a lot of fun. And there's many stories that I want to share with you tonight. Tonight's discussion intends to open a window to you into the works of this rabbinic organization and to discuss some of the stories that I'm about to share through the lens and eyes of halacha. Before I continue, I'm going to try to share my screen. There we go. Can you see that? Okay.
Yes, but maybe if you can increase the font size, Rabbi, because it's very small.
Sure.
Thank you. Great.
Is that a little better?
Yeah, that's great. Thank you.
Okay, sorry about that.
Big improvement.
Okay, apologize. Okay, thank you, everybody, and let's continue. Okay, so I want to start by telling you a story of an engagement that we were hired at HIT to manage and maintain a previously built cottage country Eruv. I'm not going to name the cottage country, but it's fairly big and significant, well-known and close to Toronto. There had been some difficulty in securing the funds for the local Jewish community to ensure proper maintenance of the Eruv. Maintaining an Eruv is actually expensive. Additionally, there was a serious concern of resistance to the Eruv from the local Gentile community. And somebody had been cutting down the Eruv wire every Shabbos for the previous 2 or 3 weeks prior to our engagement. So again, this is a scenario where HIT was called upon to provide a community resource where the local rabbinate felt that it was difficult. I want to explain this case through the eyes of a shaila and a tshuva, through the eyes of halacha. So the question for discussion, as you see at number 1 there, is a Gentile neighbor was cutting the community Eruv wire for the last few weeks. Am I allowed to carry on Shabbos? Or do I have to assume that the Eruv is down? Let's talk a little bit about Eruvin. The Gemara in Eruvin on page 11b, Yud Aleph Amud Beis, explains that one is able to create an imaginary, so to speak, wall through the formation of what's referred to as a tzuras ha-pesach. Tana, tzuras ha-pesach she'amru kana mikan, v'kana al gabeim. What is a tzuras hapesach? A kana means a pole over here, a pole over there, and a pole on top of them, almost like a football formation. So if I create an eruv around a community, I can use this type of tzuras hapesach, or imaginary doorway, so to speak, or door frame, more accurately, in order to create the imaginary walls around the community in order to render that place a rishus hayachid, or a private domain, which I can carry in on Shabbos. It's interesting that the Chazon Ish notes in his sefer called Dinim Vahanhagos, 15th parak in the first din. Hoya Omer, the Chazon Ish used to say, She'asr lisa masa b'Shabbos, af b'ayarot shemisaknim eruv. He used to say it's very problematic to carry on Shabbos, even in a community that has a proper eruv. Ki al harov yesh b'zeh michsholim. For the most part, there are many stumbling blocks when it comes to eruvin. V'yanechshav etzlo kivadei d'Rabbanan. It was as if, to the Chazon Ish, that even in a community where eruv existed, it wasn't really there, because there were so many problems maintaining the eruvin. In his practical experience, the many times that he went to look at eruvin, he found that they were inferior, that they were pasul, and therefore he was very hesitant to rely on eruvin. We're not going to take that statement literally, but we are going to take it in stride and say that eruvin, especially ones that are built even by construction experts, are eruvin that are at risk of falling. And especially in this particular scenario that we were called in to manage, what was happening is that there was one of the Gentile neighbors was clearly cutting down the kana al gabeim, the top wire that was connecting the tzuras hapesach. He was cutting it down from week to week, and they would find it broken. So they asked us to deal with this situation. Let's first take a look at the halacha. Is one able to rely on such an eruv where it's known from the get-go that there's going to be a problem on Shabbos? So the Shulchan Aruch in Siman Shin Samach Hey, Sif Zayin, says that a mavui shenitlu korosa v'lechia b'Shabbos. I won't read the whole paragraph, but basically the idea is that if a tzuras hapesach falls down on Shabbos, it is prohibited to carry in such a place. However, and I'm not going to explain the details of this din, but if the city is entirely surrounded by a wall, and then the inner walls of the city, the walls that are separating from one property to another property, fall down, in that type of scenario, one could carry even in absence of what's called an eruve chatzeres. I don't want to get into details of that, but I do want to read the Ramah at the end. The Ramah says, "Im safek im nistar me'erev Shabbos." If you have a case which is a safek, whether the eruv fell down from erev Shabbos, as linon lekula, one is permitted to go in the lenient position and say, since I don't know if the eruv is going to be down, I'll assume that it was up. So therefore, it appears from this Ramah that if I'm not sure if the eruv is going to fall down on Shabbos, then I can carry on Shabbos. However, the Mishnah Berurah in Sifkat and Lamed Dalet, which is note 4 on my page, Dalet, clarifies that in places that it's mitzuyin, where it's common that the Nachrim, the Gentiles, are mekalkulim osam belel Shabbos, where they're actually taking down the wires on the night of Shabbos, on Friday night, the Karov Levade Hushiakalkalu, and it's almost certain that they will remove the eruv. In such scenarios, one is not allowed to rely on this safek derabanan lekula. One must actually be stringent. So in our situation, we were really in a pickle. What were we going to do? Clearly, from the psak of the Mishnah Berurah quoted in note number 4, which is in Siman Shin Samech Ches of Katan Lamed Dalet, the Eruv could not actually be relied upon for Shabbos. How would we manage to fix this Eruv? How do you fix an Eruv that someone is actually going down and taking it down, is removing it on Shabbos? So this was a scenario that called for diplomacy. We didn't do anything halachic. We knocked on the door of the fellow that everyone assumed was responsible for taking it down. And we asked him, we said Shalom Aleichem to him, hello, how are you? We're here, we've been asked to maintain and manage this Eruv. He says, what's an Eruv? What's an Eruv? I said, well, the Jewish people are not allowed to carry on their Sabbath. And through these wires and poles that you see outside your door, through those imaginary walls, we're able to create a private domain and carry on Shabbos. He said, oh, I didn't know that. Nobody ever explained that to me. I said, can I ask you a question? Have you been cutting down the wire? He said, yeah. I said, why? He said, because there's a wire going across my property. Why? What, wouldn't you cut down a wire going across your property? So we sat down, we talked. He actually told me he was moving in a couple of weeks, and we arranged, I had a couple of rabbis with me, and we arranged to meet again on the day that he was moving to help him move. He was so grateful, and we were so grateful that we had made this contact, and the diplomacy had worked, and Baruch Hashem, the Eruv was never taken down again. Sometimes it's halacha, but sometimes you have to be practical and have seichel, and that's the way to figure out a problem. There are many examples of problematic ribis transactions. Ribis means prohibited interest. When a person makes a loan and he charges interest, so that's a prohibition. A Jewish person is not allowed to take interest on a loan from another Jewish person. But there are many examples of problematic ribis transactions that people may not even realize are an issue at all. There was a recent situation in which one of our rabbis who work in our office held an account in a prominent Toronto-based brokerage, which is holding many billions of dollars of other people's money and providing a platform so that they can invest online. This rabbi who held this account told me that he realized one day that his account was actually a margin account. A margin account means that you can actually borrow money from the brokerage and use it to buy stocks on loan. They allow you a certain amount depending on how much you're worth. And at the end of the month, they charge you interest for the amount of money that you've borrowed. Nominal amount of interest. They're encouraging you to overextend yourself and invest even with money that you don't have. Okay, people are familiar with a margin account. So this rabbi went and he said, let me try it. Took $1,000, he invested it, he bought a stock, and that was it. That was the trade. Then he was thinking later on in the evening, I hold bank accounts with CIBC, with Toronto Dominion, with Bank of Montreal, but I don't know this brokerage. I signed up, it's very well known. I don't really know who owns it. Is it a public company? Is it a private company? I'm not sure who the ownership is. And I just borrowed money from somebody that I don't know who I borrowed money from. So he did a little bit of research, and lo and behold, the brokerage is a private bank which is Jewish owned, completely Jewish owned. There's a small percentage of it that's owned by a non-Jew, but it's largely Jewish owned. So now he found himself in a bind. He had just borrowed money with interest from a Jewish bank in Toronto in 2021. This month, this story happened. What was he going to do? So he tried calling the bank. So he called customer service, and customer service got on the phone and said, how can we help you? And he said, does your bank have a heter iska? A who? A what? Are you Jewish? What? What are you talking about? Heter iska. Spell that for me. Heteriska. Heter iska. I don't know. We'll look into it for you. Well, can you please look into it fast? In the meantime, the rabbi said, I'm going to sell the stocks that I borrowed, pay down the loan, and I need a favor for you. If you don't have a heter iska, I'm going to ask you not to charge me interest at the end of the month. Oh, well, I don't know if we can do that for you, but let's try. Anyway, they got back to him. Nobody really knew what this special heter iska was, the special contract which we're about to discuss. This was the actual scenario. In the end, by the way, just the story is over, but the bank actually does have, they don't have a heter iska, but they did consult with a Rav before they set up their margin accounts. So I was extremely, extremely impressed to learn that. But it just goes to show that anything could happen in today's day and age. Let's continue in our on our source sheet with question number 2. Question number 2 is, my lawyer is giving me a hard time regarding signing the heter iska that my rabbi is recommending. What am I to do? So let's talk about this a little bit, expand the conversation, talk about these types of loans, problematic scenarios, and what a heter iska is. So let's start at the basics. Note number Hey or 5 is a pasuk in Vayikra, Perek Chaf Hey, that's chapter 25, Psukim 36 and 37. The Torah says, Al tikach mi'ito neshech, one must not take interest from him. Vitarbis, that's another way of describing growth or interest, where your money grows. V'yaresa me'elokecha, you must be God-fearing, and make sure that your brother has a livelihood and has what to live. Don't take advantage of him. As kaspecha lo sitein lo b'neshech, uv'marbis lo titein achlecha. Do not use your money for interest loans, and don't use your assets, your achlecha, your assets, for similar purposes. Another pasuk in Shemos, chapter 22, Parshas Mishpatim, pasuk Chav Daled, im kesef talves ami. If you're going to, when you're going to lend money to my nation, esa'ani imach, to someone who's needy and poverty stricken and he needs your money, lo sia lo kenosha. Don't be like a person who lends with interest. Lo sasimun olav neshech. Do not place interest upon that person. And then finally, in note number Zayin, in Dvarim chapter 23, pasuk Chav, again the Torah says, Lo sashich la'achicha. Do not take interest from your brother. Neshech kesef, neshech ochel, neshech kol shdavar asher yishach. Whether it's money, food, or any other type of favor, you must not take any you must not get any benefit from taking interest from your brother, from lending him money. And the Gemara says, and this is note number 8, Ches, which is a Gemara in Bava Metzia on page 75b. Not only is the lender and the borrower transgressing on the negative prohibition of lending with interest when an interest deal happens, but Elu over and below say these are the people who transgress the negative prohibition of the Torah. Hamalva, the lender. Halova, the borrower. Ha'arev, the guarantor. So you can't even sign as a guarantor on a loan that has interest in it. The ha'edim. And even the witnesses. The chachamim omrim af hasofer. Even the lawyer who is mediating or setting up a loan between two Jews that bears interest is not allowed to do that work, which is prohibited for the lender and the borrower. And the reason is because of all of these psukim. And you see the rest of that note tells us the different psukim that apply to these different roles. And all these different roles are included in the prohibition. That's the lender, the borrower, the witnesses, the guarantor, and the lawyer. They're all included in the prohibition of ribas. Remember that prohibited interest is only on a loan that is between two Jews. A loan between a non-Jew and a Jew, whether the Jew is a lender, whether the Jew is a borrower. In such a loan, interest is permitted. So there are many different scenarios where this comes up. I'll tell you also that there was a recent question as to whether, we'll discuss a heter iska in a moment, but there was a recent question as to whether a heter iska was needed. Heter iska, I'll just translate it for you. It's taking a prohibited loan and turning it into a kosher business deal. And I'll explain that in a minute. But there was a recent question whether such a heter was needed where the company would not charge any interest on their loan, but they were only charging fees to cover their own borrowing costs. So a company, in order to lend money, needed to borrow money first. So they were just borrowing with interest from a bank, and then they were lending it to another Jewish party. That's also ribas. That's also a prohibition of interest taking, and it's not allowed, even though it's only to cover your costs. So is asking your dad to co-sign on your personal home mortgage, even though the loan is from the bank. But when there's a guarantor involved, the guarantor, it's as if he's the one lending the money at the end of the day. So co-signing on a personal home mortgage is also a problem of ribas. Investing in a real estate deal where the syndicator or the general manager provides a personal guarantee is also a problem of ribas, even if it's a regular bank loan. There are many other examples, and I'll just give you a few, depending on what industry you're in. If you have a Jewish customer and you charge them for a late payment, you charge them extra, that's also a problem of ribas. If you're borrowing off someone else's credit card and you end up going over the date and there's interest that you have to pay to your friend's credit card or line of credit, so then you've also borrowed with interest from your friend, and that's also a problem of ribas. Even a landlord who takes last month's rent may transgress the prohibition of ribas if he's following the law. Why? Any of you who are landlords might know that if you take last month's rent and you hold it, you're essentially holding someone else's money. It's deemed a loan, and the law requires that you pay interest to your tenant on the last month's rent. If you do that, and you don't structure it with the Halacha Institute of Toronto in a permissible way, then you're essentially paying interest. So all of these are problematic, and they all have solutions. Every single scenario that I mentioned, whether you related to it, whether you didn't relate to it, some are a little bit more complicated, some are less complicated. Every situation has a solution. The question is, what is the solution? And where can I get the resources to manage that solution? And that's over at HIT. So I want to show you now note number 9, which is the source for the idea or the implement called heter iska, which is the shailus v'tshuvas trumas hadeshen in Siman Shin Beis, chapter 302, section 302, where Ruvain he asked a shaila from this rabbi called the Trumas Hadeshen. He wanted to give his money to Shimon in order that Shimon can in turn lend the money with interest to non-Jews. So he wanted to lend Shimon the money, and Shimon would then lend John the money in order to make money. He wanted to invest in a loan fund, in a mortgage fund, basically. That was the shaila that he asked the Trumas Hadeshen. Now, Trumas Hadeshen is a Rishon. I don't know exactly when he lived, but my guess is around the 16th or the 15th century. And this is what they were doing. They were investing in mortgage funds. Okay, So there's a problem because he wanted Shimon to tell him how much percent he's getting. So Shimon says, well, if I'm going to land the non-Jews in the community at 7%, then I'll give you 6%. So you lend me the money at 6%, I'll lend them the money at 7%, and we're all good. That was basically the problem. So the question was, is that interest? So on the one hand, of course that's interest because you're lending money and you're taking interest. On the other hand, this is business. This is not taking advantage of your friend as ha'ani imach. And this is just business, regular business. It's the time value of money. So what did the Truma Sadeshan answer? He said that I'm going to present a heter, which I'm going to call a heter iska, which is a venture. And iska just means a business or a venture. So the heter called iska, I'm going to change the loan fundamentally. I'll restructure it, or more accurately, I'll reconstruct it. It's no longer going to be a loan. It's actually going to be given as a venture, as an investment, not as a loan. And the investment will have a return, and we'll try to guess what the predetermined rate of return is going to be. And in that way, it can mimic a loan, although it's not going to be a loan. That was his suggestion. Now, it's interesting. I want to read to you the Lashon of the Truma Sadeshan. Is the reason why I brought 3.5 lines here. He says here, and this might resonate, that by providing this heter and reconstructing the loan as an investment, there are going to be some people who are going to say that we're making the Torah into a laughing stock. Chucha v'tolula. We're making the Torah into something, it says it's usher, prohibited, and we're making it permitted. So how, that's not fair, that's not right. It's a schok, a hitul, a joke. You're taking it, it's like almost like mechiras chametz or heter mechira. This year is Shemitah year in Israel. And you just sell the land to the non-Jews. It's almost that idea that people will think that this is a joke. He says, Amna mikol makom, there's a very interesting saying that the rabbis say. They say, tzadikim yelchu ba, uposhim yikashlu ba. This is Torah. The righteous walk in the Torah. And those who are negligent, those who laugh, yikashlu ba, they'll stumble in the Torah. There's nothing we're going to do. We're going to say the Torah as it's meant to be authenticated. And that is what he went on to say, which is that a heter iska will reconstruct a loan as a investment. Now, what's the fundamental difference between debt and equity? A loan or debt is guaranteed. Equity is not guaranteed. So if you want to change a loan which guarantees a return and its principal into equity, you must create a scenario where it's possible for the lender, which we'll stop calling the lender and we're going to now call him the investor, to lose money on the deal. Now, nobody who wants to invest in a mortgage fund really wants to lose money. I mean, they understand there's a risk of default, but there's going to be probably there's going to be a house that's going to secure the loan. There's a much higher level of security when it comes to debt as opposed to equity. And you're asking him to exchange that for a lower level of security and a higher level of risk. Who would do that if you're not going to pay much more money as for the return? Who's going to do that? So the rabbis instituted what's called the severe oath. And that is that if a person wants to, if this borrower, or we're going to stop referring to him as the borrower, and we're going to start referring to him as the money manager. Now, he's got Reuven's money. This is Shimon. I've got Reuven's money. And now I can do with it whatever I want because I can invest the money. Now, in order for him to deny that the investment made money and earned the predetermined rate of return, which Reuven was expecting, the manager was going to have to take an oath, the most severe oath, holding a Sefer Torah in front of the entire congregation and the rabbi. That's the condition whereby he's able to say that your investment lost money. It didn't make the predetermined rate of return. So that's the concept of heter iska. Now, no rabbi and no beis din is going to allow anyone to take a Sefer Torah and make an oath on a heter iska, because we know what the heter iska is. It was intended to be a loan, but you can't be a loan because that would be prohibited. We turned it into an iska. No rabbi is going to allow that to happen. And therefore, it's secure. Whatever the predetermined rate of return, in other terms, would have been called the interest rate, was determined to be, that's the money that the person is going to make. And the heter iska can be implemented. Now, it has to be implemented. It has to be done and has to be taken seriously. I'll bring your attention to note number Yud, which is a fascinating article from Charles Wagner. Does a heter iska increase the risk of litigation? March 22nd, 2013, and I included the link to this article. It's a fascinating article which describes a problem with heter iska. The problem with heter iska is lawyers don't like it. Because you can imagine that you want to invest your money in a loan or lend your money, and somebody's asking you, you're a bank, let's say, you own a bank, and you're Jewish, and you want to lend money to other Jews. And the rabbi is asking you to structure it as equity, restructure it as equity. Don't lend it. Your lawyers are not going to go for that. They're going to say, that's too risky. And you're going to say, yeah, but the rabbi says that nobody would allow a Sefer Torah to be held in shul, and nobody's going to swear in front of the entire congregation. It's not going to happen. The lawyers aren't going to go for that anyway. So Chuck Wagner wrote an article about whether or not a heter iska is actually going to be taken seriously in the court of law, in the secular court of law. So lawyers should take note of this. So this was an actual case that was brought before the Ontario Superior Court, where a company called 625882 Ontario Limited and Batya Wagner sued a family called the HaKohens, and the case was about a loan that had transpired. However, in order to collect interest, Miss Wagner had implemented a heter iska on the behest of her rabbi, and now the HaKohens had stopped paying, and they claimed that they didn't have to pay because the money had not been lent to them, but it had been an investment, and their investment was lost. So the story went that Batya Wagner asked the judge for a summary ruling, and the judge ruled, because there are really three options if we think about it. There were three options to consider here. Either the judge would say that a heter iska is a legal fiction, and this is a loan, and therefore there should be a summary judgment throwing out the case as the defense, and the decision would be with the prosecution. Or the judge would enforce the heter iska, but he would only enforce it on its terms. So many of the terms of the heter iska, besides for the oath that one has to swear, which you can't really practically do, but there's other conditions in a heter iska. I didn't mention them, but there are many other conditions in a heter iska as well. and nobody's going to be able to fulfill them. And therefore, the judge would say that, okay, so this loan is not a loan, it's a heter iska, but it should be governed by the rules of heter iska. And clearly the money is still owing. Or he would say, this is not a loan, it's a heter iska, but he would ignore the Hebrew rules of a heter iska. He would ignore that, and he would just say it's not a loan, it's an investment, and therefore they have the right to hear a full trial. In the Ontario case, the judge ruled with the middle option, and he said that heter iska is binding, it's legal, but it's legal according to its terms. So what Wagner was pointing out in his article is that lawyers beware, heter iska will be taken seriously in court. So while it's a good option from a halachic perspective, the lawyers who did express concern do have the right and do have the right idea that they should be concerned, because heter iska will be taken at face value in court. Now, it'll be taken at face value, but there's enough clauses in there to make sure that it actually works. That's true, but lawyers should get themselves involved in every aspect of what their clients are doing, even if the clients say that it's for religious reasons. Now, I'll tell you that sometimes lawyers get involved and they don't, they involve themselves too much, because the clauses that are suggested negate the entire heter iska. For example, in Exhibit A, hopefully you can see that. I'm going to try to enlarge that. Yeah. So in Exhibit A, this is from an email. I just didn't want to put it into the exhibit, but good afternoon. My client wishes to add the following sentence. Nothing in this iska contract derogates from or changes the obligations, terms, and conditions and rights of either party as specified in the agreement, including the vendor's right to assign the VTB. So basically, I'm not going to translate all those legal terms there, but he's asking us to say that even notwithstanding you're changing the loan to the heter iska, to the investment, we're going to say that the client has the right to reestablish it as a loan whenever he wants. And obviously we can't do that, because that will just negate the entire heter iska. This is another example, Exhibit B. I can't enlarge this one, but you get the idea. The heter iska was written for 4 million and change. That's how big the deal was here. And it's fairly recent. You see that the end date on the heter iska is April 6, 2022. And this was submitted by our client, who is a Jewish client, who was doing a deal with Jewish investors, and his lawyer had drafted a heter iska, and all of these markings here, you see the highlights and in pink, etc., are from the rabbis who are commenting on the many multiple instances in this heter iska where it invalidates itself from the language that it's using itself. So lawyers should for sure take this seriously. Rabbis will have to take this seriously, and they'll come to a happy meeting of what can and can't be included. But what I do want to say here is, and this is almost the thrust of the presentation, is that HIT is an organization that has resources. We consult with lawyers. We have our own lawyers in all different areas of law, and we work with lawyers. We understand legal terminology, and we understand business as well. And these are some of the resources and advantages that are there for the community in these kind of sometimes complicated and sometimes not so complicated scenarios that are almost done daily. Okay, I have some questions here. I'm going to stop just to address some of the questions. I noticed that there's a chat here, so I'm just going to go to the questions. and say, and repeat some of them. Do all mortgages in Israel have a heter iska attached? The answer is yes, but you should still find out. There's no rule that if you're in Israel, there has to be a heter iska. There has to be, according to halacha, but there's no rule saying that there is going to be one just because you live in Israel. But for all intents and purposes, any bank in Israel that has any type of legitimacy is going to realize that they can't do business without a heter iska, and therefore they're going to have a heter iska. You have another scenario. There's 5 Jewish people, 2 are investors, 1 is a broker, 1 owns the company. How does this work? Is the broker getting a percentage or a profit? Okay, this is a specific question regarding a specific scenario that I'm not going to go into. And finally, what are the fees for our services? So I'll just repeat the words that one of the lawyers that we work with, Avi Sugar, I don't know if you know him, he lives in the neighborhood. We work with him a lot. He said to us, he says, you guys don't charge enough. He says, you know a lot, and you could easily charge as much as I do, but you don't. There are nominal fees, and we make sure that our clients are comfortable with them before we start, but we're a not-for-profit. It's a charity, and it's meant as a community service, and we don't charge enough. Okay. Moving on. Rabbi, how much time do I have?
You have about another 12 minutes.
Okay. Another service that is offered by HIT is validating a legal will and testament through the issuance of a halachic inheritance contract. I'm not sure that you've ever heard that term before, halachic inheritance contract. The reason why you may not have heard that before is because we coined it. Previously, it was called a halachic will, but the lawyer we were dealing with at the time, a prominent woman who lives in the Wilson and Bathurst neighborhood, a frum lady, she didn't like the terminology, a halachic will, because there is no such thing as a halachic will, because that terminology is self-contradictory. According to halacha, there's lots of rules. For example, a firstborn gets a double portion. Male children inherit, female children do not inherit. Husbands inherit their wives do not inherit their husbands, and so on and so forth. So lots of rules. So to call something a halachic will doesn't really make sense. If you want to create a will that abides by halacha, then you need a contract which enables that will and makes it compliant and legitimate. So we call it the halachic inheritance contract. And we tell everybody, do your will with your lawyer. We don't do wills. We don't want to do wills. Come to us after you know exactly what you want to do. We do recommend that when people think about their wills with their lawyers, that they should do something according to the laws of the Torah. Maybe the svarim that you have in your home maybe should be divided according to the Torah's way of thinking about inheritance, or something minimal, because the Gemara does say that the rabbis, Chachamim, the Chazal, did not like when people avoided their halachic obligations entirely, but you can almost entirely avoid them. And not only can you, but many of the contemporary poskim in our generation say you should, because otherwise it will create a type of a kinna, jealousy among siblings. And we all know that almost many of the mediation services that we provide, and many, unfortunately, you hear stories of families that are in courts, siblings and family members with one another over inheritance, and it's not comfortable, and therefore people should be as clear as possible. Put it that way: be as legal and as clear as you can in terms of your will. Don't leave anything to interpretation. Now, one of the things that you should do is make sure your will cannot be challenged in a beis din. And in order to do so, some poskim hold that it can never be challenged even in a beis din, but there are poskim who hold that it can be challenged in a beis din. In order to do so, you need a halachic inheritance contract. going back to our notes, this is really the final notes. Yud Aleph, number 11, is a Ramah in Choshen Mishpat. In chapter 108, Sif Gimel, where the Ramah talks about a shtar chatzi zachar. What's a shtar chatzi zachar? It sounds like a contract which is like half a male. What's half a male? So it used to be, in order to get a girl married off, you had to assure the groom's family that you were not going to cut the daughter out of the will. She was going to get some of your inheritance. But not a whole portion like the males, but a chatzi zachar. You'd give her half of what the males were going to get, what your sons were going to get, that you'll give the daughters. That's it. That's the minhag, the way it was in the Ramah's time. I think today people like to be more or less equal. So umashenogim, it's the same concept. Mashenogim b'shtar chatzi zachar shekosim achshav libanos shenotlim b'chol sheyamatzeilo. They get a portion of inheritance, kemo ascharim, like the males, mishum dekosiv lam derech hoda'a, because you write to them as an admission, shechayev lahem sachma, that you admit that you owe them money. V'lo yipater ela kishenosim lahem kemo ascharim. So this is the way a shtar chatzi zachar works, and this is the method that we follow in our halachic inheritance contract, which is we ask those who are making the will, the benefactors, to admit that they owe their non-halachic inheritors an amount of money that's larger than their estate will ever be. So we ask you to choose a number. I remember the first one I did, I said, I was new then. I said, why don't you choose a number larger than your estate's going to ever be? So he said, I don't know, should I do 100 million? No, I'm not sure that's going to be enough. I'll do 200 million. That was my introduction to the halachic inheritance contract. So he did 200 million. So you choose a number and you admit that you owe that to the non-halachic inheritors, or your daughter in the case that we're speaking about. And then you say, and that amount is owing, unless my halachic inheritors, my sons in that case, will agree to share my estate according to my directions that I've set out in my legal will. That's basically it. That's what a halachic inheritance. It's halachic. There's a lot of terminology in it. There's a lot of conditions, etc., etc. It's a contract, by the way, that we designed together with a legal team, and we paid a lot of money for it. And if it would ever be found, it's not necessary to ever bring it into a courtroom, but if it would ever be found, it would be a legitimate document and it would be upheld, we believe, in court. So that is a halachic inheritance contract. And again, we encourage everyone to have a halachic inheritance contract so that there's no chance that their will could ever be challenged. I want to conclude with one last case or story, and I'll just tell it as a story. It's a mediation that we conducted. I remember the case of Sam Wiseman, who was in the residential construction business. He was hired by Stephen Goldman to build a home. And as the winter was approaching, Sam, who was the contractor, hired David to do the snow shoveling at the property, which was almost complete. Stephen was the homeowner, Sam was the contractor, and David was the shoveler or the landscaper. So Stephen and his family moved into the house, and David's company continued doing the snow removal. David sent the initial invoice to Sam, who turned it over. Sam was the contractor, who turned it over to Stephen for payment, which was made. For the duration of the winter, David continued to send his trucks to perform snow removal, but he neglected to send invoices. This is a true story. As things had gotten busy for him, both professionally and personally. As spring arrived, David needed his money, and he was out of pocket to some of the money that he'd paid his own employees, and he sent the invoices to Sam, who was the contractor. He didn't hear back. He called Sam, who told him that he was calling Stephen, the Goldmans, and he was trying to get his money from the Goldmans, but he was being ignored. One day, Sam was driving by the property, and he knocked on the door and asked if he could speak to Stephen. Someone else answered the door, and he advised Sam that the Goldmans had flipped the house and that they were new owners. So David went back to Sam and said that since Sam was the one who hired him, he technically owed David the money. Sam felt differently and thought that if anything, the obligation was to pay was entirely Stephen, who was the homeowner at the time. But when he tracked down Stephen, eventually, Stephen said he wouldn't pay the money. Sam argued with Stephen, but Stephen wasn't giving in. And he said, if you want to sue me, go right ahead. Sam and David were both observant Jews, and they wanted to see if there was any way that they could resolve the dispute in a rabbinic framework, and they came to HIT for mediation. After presenting their respective cases, the parties asked the mediator what he thought a possible result that a Beth Din might provide. The rabbi replied that this might be a case of hamotzi mechavero al varaya, that if you want, David, you want to collect money from the contractor, then it would be up to you to prove that the contractor took responsibility for your fees. The contractor said, I didn't take responsibility. I had always passed along the invoices to the homeowner. And in fact, the homeowner had to pay the original invoice. I didn't take any responsibility. So the rabbi said, it's probably likely that the Beth Din will not enforce payments from the contractor. However, since you were the contractor and you were the one who made the shidduch, meaning you brought David to this homeowner, and he provided his services based on your business and his relationship with you. He didn't know the homeowner. So it would be your responsibility to get the money from Stephen on behalf of David. So while you don't owe the money, you might be responsible to get the money. So after this assessment that was provided by the rabbi, he asked the parties what they thought would be a fair compromise. And together, after a couple of hours of discussion, some kichel and herring, and a couple of glasses of schnapps, David and Sam agreed that Sam would pay half the invoice and David would write off the other half. Baruch Hashem, that story ended in shalom, and that's really the goal of all mediation. It's not easy to go to court, it's not easy to deal with lawyers, and it's not easy to go to Beth Din. It really isn't. It's a complicated process. Mediation, especially when it comes to parties who really do want to seek a solution, is very, very effective in our experience. I hope I've successfully opened the window to what we do at the Halacha Institute of Toronto. Of course, there's much, much more than that, and I welcome all of you. My number is on the screen next to my name, under my face, and I welcome all of you and any of you to give me a call at any time, and we'll be very, very happy to help. I very much appreciate this opportunity to discuss words of Torah with you, discuss some of what we do with you, and I'm greatly indebted to Rabbi Diamond for inviting me. Thank you very much, and have a good night.
Rabbi, do you have a couple minutes in case there are any questions? Would you be willing to answer some questions from the...
Of course.
You maybe want to stop screen sharing so we can go back to the gallery view? Thank you. Does anybody have perhaps a question that they wish to ask Rabbi Haber from his presentation? Thank you so much for that amazing, wonderful, insightful presentation. I know there's some lawyers here. Do not feel pressured to ask Rabbi Haber a question if you are a lawyer. Maybe you shouldn't ask him. I don't know. Anybody? Aurelia, I think is that your hand? Yeah, go ahead, please.
Hi, good evening, and thank you so much for a very insightful shiur tonight. Rabbi, why do we not know about this halachic inheritance contract? Why is it not advertised? I mean, here we are, many of us are in our 50s, 60s. Even people in their 20s, young marrieds should all have wills, but nobody tells us about this.
Yeah, I agree. We don't do a good enough job on the marketing, and I guess, we as rabbis know our limitations, but we're gonna endeavor to hire a firm to help us get the word out. So thank you for your suggestion, and bli neder, we will pursue that.
Overwhelming, thank you.
Anybody else?
Thanks, Rabbi Haber. Quick question. The star Chatzi Zachar, that's legally binding. How do you structure it so that it's legally binding and
Right.
also legally binding?
Yeah, it's actually the original halachic will had double mechanisms, which the lawyers felt were not going to be legally binding. The way that you ensure that it's legally binding is by, you see, there are a couple of problems. First of all, what's legally binding, what's not legally binding, and if something is legally binding, what are its tax implications?
Right.
So those are always the way
Like I
that a
heard
lawyer is
sometimes
going
they
to.
do trust funds. Is that like there's trust funds or?
Yeah. So in other words, what we're presenting is a contract which says I owe you $1 million. Now, if I sign an IOU that says I owe you $1 million, then I owe you $1 million. If it's signed with witnesses and it's a legal contract, then I owe you $1 million. If that's what I signed. So in this particular contract, there is an admission of a debt that would go to the non-halachic inheritors if the halachic inheritors don't listen, basically. So it's conditional. And yeah, we did review everything we did with the lawyer.
That's legally binding without any consideration. Meaning, if I just make it up and I say I owe you $1 million,
no, I'm going to send. I can send you the contract. We don't actually release it to the internet, and that's actually our hashkafa. Maybe that contributes to why people don't know about us so much. But we never give out our documentation because I showed you a couple of examples of heter iskas that were just, people I'll tell you a funny story. We were asked to review a heter iska twice, once with a heter iska and once with a contract that was developed in order to enable a business to operate on Shabbos and Yantiv. And the Halacha Institute was asked to review it. Now, reviewing documents, we do it on a preliminary level, but then we always give it to the upper echelons, to the Rabbanim to sign off on. So we gave it to Rabbi Felder. Rabbi Felder takes a look at it and he says, "Where'd you get this from?" So I said, so-and-so is our client and he's asked us to review. He says, "I wrote that contract. That's mine. So where'd you get this?" So he had no idea who the client was, why it was being used, if it was even appropriate in the scenario that it was being used in, but that's the way things go. So we're very careful because we want to not only help people by providing them resources, but we want to actually make sure that they're implemented properly. And we can only do that if we kind of hold on to our documents. But I'm happy to share with you, Rabbi Bergman, our halachic inheritance contract, which we do give out, by the way, and you can use it, and it's properly executed. There's witnesses. There's it's encouraged. Our lawyer has said it's encouraged to have a lawyer on site, someone who is able to seal a document, etc. That's encouraged, but not absolutely necessary.
Aurelia?
So am I to understand that every heter iska has to be specifically tailor-made? So there should be a template, but everyone is specific to a negotiated deal?
I'm not exaggerating and I'll tell you, I've never done the same heter iska twice. they're not forms. I don't know where the concept came that you can download a form from someone's website and just write the numbers in it.
So
There
that means
are
I did it
there are
wrong.
some, yeah, I know. There are some basic heter iskas which can be utilized in almost any scenario because they're so basic and bare bones. But those are the type of heter iskas that no lawyer wants to use because they're just very free and open, and none of our clients don't want to use those.
So what's your phone number?
It's on the screen there.
I
416.
can't see it, yeah.
You see it?
416.
535-8008. Call now. Sale going on. You get
I'll get a reduction on the fees. Thank you, rabbis.
Charlie,
Rabbi,
go ahead, Charlie.
you mentioned that you look at ketubot and you find mistakes in it, right? Now, my question is, why are there mistakes? What's a typical mistake?
Yeah, so we don't, if you understood it that way, I'm sorry, I apologize. We don't, you'd have to invite Makobel to your house to do that. But we don't ask people for the ksubas. When somebody says to us that our ksuba has a mistake, then we will fix it for them. So there's two different contracts that we use. One is called the ksuba de erchasa, which means a ksuba that's lost, which happens, and there's ramifications. You shouldn't live together with a spouse without a ksuba, and a ksuba de nafal to usa, which means a ksuba that has a mistake in it. What are some of the mistakes that I've seen? I've seen ksubas that were written on the wrong date. I've seen the names of the cities grossly misspelled. I've seen the names. Well, a guy says he's Yaakov ben Tzvi, and in the next line, that's at the top of the ksuba, and at the bottom of the ksuba it says Yaakov ben Avram. And the reason for the mistake is because his grandfather's name is Avram. So they filled in his father's name at a certain point, and then they got mixed up, and the rabbi got mixed up. So there's there are times where that happens to it. It's not the most common occurrence, but we definitely do that.
So one should actually read the ketubah very carefully.
Yeah.
After it's given.
The reason for the custom to read the ketubah under the chuppah is so that, and you give it to a big rabbi there, is so that he can review it, and that the people who are sitting in the congregation at the chuppah can listen to hear if there are any mistakes. That's the reason we do it.
Okay, thank you.
So let me offer thanks to Rabbi Haber from everyone listening. Thank you so much, Rabbi Haber, for opening our eyes and presenting us with the work that the Halacha Institute does. As I said at the beginning, my comments, I think that there are many people who haven't been exposed to the Halacha Institute and the breadth, the scope of what it's involved in, and just how much it sort of serves the broader Jewish community, from things like ketubah to multi-million-dollar deals, and making sure that all of the things that we are engaged in comply to halacha. So thank you very much. Chazaku Baruch, may you continue to do work for the community as you have. And I look forward perhaps inviting you back to share some more of your insights and knowledge and experience with the community at a later date. So thank you very much, everybody. Thanks for joining us tonight. I wish everybody well. Thank you, Rabbi Haber. Yishar kol
Great
chacham.
pleasure. Be well. Nice to meet you all.
too. Thank you, everybody. Good night.
Thank you.
Good night.
Right.
Good night, all.